I often find so much of the legal vulnerability, honestly, is it's the unforced errors. It's the lack of doing that homework, the lack of intentional really strategy around those data points and having some management around your digital presence and knowing the data that you're fueling at a pretty granular level.
That's Alysa Hutnik, Privacy and Information Security Practice Chair and a partner with the law firm Kelley Drye. Alysa has expertly helped clients to navigate the complex intersection of data privacy and digital marketing for nearly 24 years. Her work includes helping clients to identify important opportunities in this time of rapid changes in data privacy policies and actions, designing sound compliance programs and data strategies, and defending companies before government regulators. With the recent surge in data privacy enforcement actions, lawsuits, demand letters, and investigations, Alysa has been an up-close witness to what one regulator described as a reckoning in digital privacy. Her expertise spans the intricate patchwork of federal data privacy regulations, state privacy laws, and the rapidly evolving health-specific regulations that are reshaping how healthcare and medical device companies can collect, store, and share digital marketing data. In today's conversation, we explore the current enforcement landscape and why Alysa believes consent-based strategies and privacy-first marketing aren't just about compliance. They're about achieving an enduring competitive advantage. You won't want to miss this episode of The Digital Clinic. Can you describe a little bit about the work that you do around data privacy, the role that you play on behalf of your clients, and a little bit about what I think is your fascinating career history as well?
Oh, sure. So I've been doing this now for almost 24 years, which is really just crazy. Time flies when you're having a good time. I'm a regulatory lawyer, which, you hear privacy lawyers, and I think to the outside world that sounds like the same thing for anybody who wears that title, and it just changes so much depending on what you focus on. So I'm based in DC. I represent clients who are investigated by government enforcers who are focusing on consumer protection law or privacy law. So that's the Federal Trade Commission. They initiate a lot of different types of investigations. And so I represent companies in defending against those, as well as state attorneys general who enforce their consumer protection laws, and privacy being a major focus over the last few years. That's really taken up a big part of my docket. So I really enjoy doing those. We're really making law as part of that, particularly with these new laws. How do you interpret them? And there's a lot of both advocacy and education in that to help educate regulators who might not know the behind the scenes workings of how do you operationalize some of these requirements in a way that is really practical and realistic. So I really appreciate that aspect. The other half of my docket is working with companies to figure out how to comply with these laws. And this is really, I would say, my passion because I just get to be a total nerd and learn all different kinds of businesses and different kinds of practices and operational stakeholders across the enterprise, often, who each have their own business objectives, and you need to try to weave in what they need to do that works within the business fabric, but also addresses what the legal and policy issues are. So that's the other side of what I do. The road to get here, winding, but maybe if the through line is that it just always followed what was interesting, and you get to work with a lot of really really interesting people, a lot of interesting different kinds of industries and businesses. So that's just always supported. I've been at the same law firm my whole career, which is I
That's
think a
amazing.
dinosaur these days. Yeah, you don't hear that a lot, but
Yeah,
I think part of it is I was always able to do what I'm doing. And maybe half the time they didn't know what I was doing, which was just fine, so long as,
right.
I nobody tried to stop me from doing this, and the whole practice of law and digital advertising and these areas I think have just really opened up before our eyes. So it's been and continues to be a fun ride.
Yeah, it's a very interesting time to be doing the work that you do. Privacy regulations have become absolutely Byzantine over the last few years. Can you describe sort of the tapestry, the hierarchical structure of privacy regulations at the federal level and then down to the state level? And in particular, because our audience and we are focused on healthcare and medtech, the way in which privacy laws are narrowly focused and even more restrictive for healthcare and medtech.
Sure. So the word on your bingo card, usually in the center, is patchwork. That is what comes up the most frequently. And partly it's because we've done it over time and often tried to address it via different sectors. So at the federal level, health industry was actually early on, obviously, intuitive, right? Health medical records should be protected. And so you have HIPAA, but HIPAA is really narrow. It was about health insurance. And so it only focuses on healthcare providers, health insurance companies, and a thing called clearinghouses, which doesn't come up a whole lot. You often hear as soon as somebody says medical records or health related records, they're like, it's HIPAA. Meanwhile, there might not be any HIPAA hook there. So that is one narrow um, set of laws and regulations that go with that. Then you have what we'll call just general broad consumer protection laws. The Federal Trade Commission enforces Section 5 of the FTC Act, and that is unfair and deceptive trade practice laws. And we saw over the last number of years a lot of health related privacy enforcements on if a practice is unfair, as well as if a company has misrepresented something about their privacy practices under the deception prong. So that there's some small regulations within the mix there, but those are the big federal laws that apply. And then we had a boom time of comprehensive privacy laws enacted in a number of states. We've got 20 states with comprehensive privacy laws. Those regulate sensitive data in particular, and health records, medical related records are often right under that sensitive data definition. And then maybe more in vogue over the last few years are very specific types of privacy laws, really focused on health laws or reproductive sexual health types of data and additional protections and restrictions around that. And then if you layer on different types of sensitive data, let's say teen data, you can have teen and health data, or social
Right.
media practices that bring in, we'll call X factors that then could trigger possibly other laws on top of that.
And some of the laws, particularly at a state level, are even more restrictive than anything that might apply at a federal level. And so, as you said, there is a patchwork. How should digital marketers in healthcare and medtech think about and reconcile this patchwork as they consider how to instrument their sites to support digital marketing while ensuring compliance?
So one, I would say there's, multiple stages of grief. And I think for all med, health, ad tech, like you just got to get through the stages of grief. Like there was a
Right.
before times and there's an after times. And I find often we're still, working through the therapy on, but this is, what do you mean? We have to do it a very, very different way than I had in my budget and business plans and revenue targets. And that's just get there. And then focus on the creative ways of now what. And I think that's really a big part of where I'm spending my time these days because there is a path forward, but you need to really do it with very clear eyes and understand the landscape. And I'm finding that those companies that have gotten over, the fifth stage of grief and are focusing on, all right, let me just really know what the issues are. So then I can brainstorm with legal or privacy or whoever your stakeholders are to come up with what are the array of solutions we have to get there. And so sometimes that is a consent strategy. And what does that really mean in this context? Others, it's getting really creative with privacy enhancing technologies and really thinking about where we can have aggregate types of data. And even a third bucket is the restrictions are around using sensitive data to target, but there's not restrictions around using personal information to target. So, how we can get really adept at using aggregate trends that focus on sensitive topics, but come up with pretty rich personal information based audiences. And there's ways to create some safeguards against health inferences to be really very pointed and very effective. And there's also just contextual advertising, particularly on certain publishers that may be very focused on audiences that you want to reach. So I think, we've had the all you can eat buffet in ad tech for quite a long time. And it was easy in many ways. And now it's not easy. And you actually have to be better. And we have AI tools. It's very competitive. And just because it's competitive doesn't mean you stop at like the short term. I have to do what I can do to get over this next quarter. It really is about what's your short-term strategy and then what are you building for in terms of the longer term strategy to
Yeah.
outrun the others.
Yeah, absolutely. We work with our clients over time to build a very robust first party data strategy so that they can do the sorts of things that you just described in a compliant manner,
Right.
along with HIPAA compliant data solutions. Well, let's sort of jump back to the current state of enforcement. both governmental enforcement and also litigious enforcement around these privacy regulations. Can you give us a sense for kind of the current state of lawsuits, of demand letters, what folks are grappling with, and what the risk profile is for digital marketers in the space?
So it's never been more active. I mean, that's really the bottom line. I had one regulator explain to me, there's going to be a reckoning, and partly, it's what do you see that is public and what do you not set you see yet, because we are dealing with a ton of non-public investigations. So maybe starting at the outside and looking in publicly, we've seen so many of these private lawsuits alleging wiretap related claims, but a
Right.
big focus there is on sensitive health data and those facts, the allegations of you're disclosing XYZ's medical diagnosis or interest in looking at various medical or health related topics. Judges have not been too empathetic for technology companies where those are the facts. And so a lot of those cases are getting past a motion to dismiss phase and settling. So you don't have resolutions of those cases that might stop the tide of these lawsuits and demand letters from just continuing and amping up. And so that is a very high volume of pain point for a ton of companies. Ad tech companies, I think, are being asked to indemnify based on kind of technology that they're using, and it's giving promises that you really can't promise because it's unknown. We're going to have to litigate these cases until we get a true, clear answer on that front. So that's for now. In some ways, that's a cost of doing business, but you can certainly mitigate what data is being shared across the ecosystem in ways that can mitigate that. So that's, I would say, the private parties, but there are hundreds of non-pending investigations by state attorneys general, the California Privacy Protection Agency, the Federal Trade Commission that very much focus on health, medical, wellness, digital advertising practices. In my investigations that I've been handling, ad tech is constantly the number one issue. It really is. And when you have health data, that's the plus factor that allows them to sink in a little bit more so in terms of their sights on what practices they really want to change and make an impact on the industry. Every settlement that you hear publicly announced, there's a narrative around that, around here is a priority issue. Here's what we saw that was not okay. And certainly you're expected to know the law and comply with the law. But once you have a public announcement of a settlement, you're then on a willful notice on did you see what the announcement was? How do your practices compare to that? Did you take any steps thereafter? And the floor of, let's just say, fines and remedies keeps going up as a result of just this knowledge. How long has this law been out there?
Right.
So that's a big part of it. You'll know from the public headlines, health has been a frequent topic in these cases. Certainly, there was the FTC cases over the last 5 or so years. Most of those were health related, period trackers and health data for audiences, and the hypothetical even of providing data as a data broker so that some companies could target sensitive locations using health information. So those were very big areas of focus. But you had even the California Attorney General's office did the Healthline enforcement recently, and that's a publisher putting media out there and having URL strings that showed the titles of articles that people were reading that were very health specific. So you've been diagnosed with diabetes type articles that was being shared programmatically. So there's not black lines for a lot of these. I think nuance is a really important component. And then coming up with that operational strategy around how does this apply to your practice and your data, your first party data? What are you providing access to in what form? There's a lot to be done and still be able to have a vibrant, robust business in this space. That's I think the bottom line.
I think I understood you to say that each time there is an announcement of an enforcement action, the announcement and the specificity in the announcement is expected to be taken on board by other players in the space. And so the implication is, okay, you weren't involved in that action, but you should be aware of it. And then you should be complying with what's been clarified in that judgment, in that settlement, correct?
That is correct. It's not blessed, what I'll call business guidance. Sometimes regulators put out a published business guidance. If anything, it's more pointed. because you have very specific facts that are alleged in the complaint that is made public, along with the settlement that says this is what the company shall do. I know that headlines often focus on the fine that the company paid, but honestly, the injunctive terms are just so much more impactful because they speak to with very particular language. What does the company have to do to comply with the law going forward? And it's not usually just comply with this provision of, let's say, the CCPA. It talks about particular program related changes that the company will do, often as we'll call it mitigation to make sure that they're complying with the law. But that can give a lot of insights in terms of how regulators are interpreting their laws and their expectations as to what companies should be doing.
The other, I think, really big implication of what you just said is around the health line enforcement action. Part of the problem was URLs that were descriptive with regard to health condition, treatment, that sort of thing. And I think there's been so much confusion about the OCR guidance out of HHS and then the subsequent AHA versus HHS case
Yes.
that many people believed that the disposition in that particular case eliminated the need to be sensitive around what was called the prescribed combination, that combination of
Right.
identification and URL. But that clearly is not the case. And so I'm interested in your teasing that out. And then I'm also interested in what you think is going to happen with additional HHS regulations that I think will come back over the top and say, okay, we didn't do it right the first time, but we're coming back with the same information. We're just going to comply with the Administrative Procedures Act and get it through this time.
So one thing is everything is political. I'm in DC, and you know what? Each agency is a political machine in its own way. But don't let that be the kind of, I guess, shield to think that you don't need to do anything just because you might say this is a more pro-business administration. So maybe just to dial it back a bit, we had this very clear HHS bulletin that was specific about ad tech data and making sure you understood the difference between when data was PHI regulated by HIPAA versus non-PHI. And so there was a rush to do audits on websites and making sure you understood when certain tags were firing in a, let's say, patient logged in state versus not. And practices were really designed around that. But after that, and this is, I think, something that probably got missed by many, is the FTC put out its own business guidance, which is now no longer on its website, by the way, which really expanded beyond the PHI, the HIPAA side, and went to talk about what about just people's health related information just being put out there. And the FTC, how we say, is broader jurisdiction. And that developed a ton of different cases. We have enforcement examples where there was discussion around pseudonymous IDs, even if they were hashed. That's a data security measure, not a privacy measure. Hashed for targeted advertising combined with IP address plus come up with your different attributes. That should be looked at from a privacy perspective. And so the formal designation of does HIPAA apply, does it not apply was less relevant than what information is actually getting communicated outside of a first party context and in what form, what purposes are those data being used for, and getting really granular around that. So, flash forward to the present, maybe we don't have that anymore because we've got an FTC and HHS and a court ruling that really put pause on that whole side of it. But what we have instead, I would say, is even more active because we have state AGs under state privacy laws, and we have the plaintiff's bar under the wiretap suits. So the risk exposure has not diminished. You just have different players who are pushing those arguments. And so I think from a factual matter, it still comes down to you have to have good hygiene for your advertising practices. And you really do have to put in the work to know what information is getting conveyed and in what ways. I often find so much of the legal vulnerability, honestly, is it's the unforced errors. It's the lack of doing that homework. Um,
Right.
the lack of intentional really strategy around those data points and having some management around your digital presence, and knowing the data that you're fueling at a pretty granular level.
You touched on wiretapping, trap and trace. That seems to me even more problematic in that those laws were created a long time ago before digital was a thing. And so now they're being forced into this new context in a way that doesn't necessarily make a lot of sense and is really, really vague. Can you talk a little bit about kind of a little bit of the history and then what you're seeing in terms of success or failure pursuing that legal strategy?
So it still, I think, shocks people when they get these demand letters and they've been lucky enough not to have received one until the present. And you dust it off and you say, wait, this wiretap law? Isn't that what was, at issue in the 70s when people were trying to tap phones or maybe watch The Wire? And so you kind of have these images from that. But no, you have a federal wiretap law, which does not have a private right of action. That was really enforced at the federal level in the way that we are kind of intuitively go to from a communication standpoint. But you have states, and California being one of them, incorporate it and apply, and it's applicable to the internet in those contexts. But it also has a private right of action. And so you had a plaintiff's bar that had been many of those lawyers had been filing lawsuits based on texting practices and calling practices, and the Supreme Court narrowed the definition of something that really hampered a lot of their ability to file those suits anymore and get some easy money. And we saw them just migrate to this creative wiretapping concept around tools on the internet that help with tracking. Originally, it was tracking consent to be a defense to these texting related lawsuits. But then that really migrated to tracking generally. And because it is expensive to litigate, after there was enough rulings that it made it clear that companies face some risk of having to actually fully litigate these cases when a motion to dismiss early on is denied. You have to put in the funds to do discovery and to risk whether you might get an adverse ruling and you might have to appeal and you might, it's a investment in terms of a legal journey. And so many companies settle, particularly when they get a demand letter where they have to weigh the costs of this demand is X amount and I never have to litigate and they will go away, or I will litigate and pay six, seven, or more figures to really go the distance. And so that is encouraging to the plaintiff's bar when they can get quick money. And that is exactly what they saw. There was, I hate to use the word methodical, but there is pretty intentional focus. Take it by each different type of provider tracker, and you'll just have cut and paste complaints and demand letters focusing on one type of technology and then moving on to the next technology and so on and so on. And really, nobody was left unscathed from that, whether you're B2C or you're B2B, whether you're the technology the provider or you're the site itself using the technology. Everybody has pretty much received one or many of these at this point.
And I've heard you say in other contexts that there's a substantial amount of venue shopping as well to ensure that the cases are filed in a context in which they're likely to not be summarily dismissed.
That is true. Although I will say the bulk of these cases are still being filed in California, but they're being filed throughout California. They're being filed in the form of mass arbitration demands, single arbitration demands, state court, federal court. They are happy to spray these cases in lots of different places to make sure that all bets are made, and it's so far it's proving to be pretty profitable.
I've heard you say that consent is a defense, but I am sure there are very important qualifications. So can you talk a little bit about that?
Yes, it's a really important point because you go to a lawyer often and you say, "Well, what's the answer? What's the defense? What do I need to do that resolves this entirely?" And I really don't like lawyer answers that say it depends, so I'm not going to say that. But what I will say is consent is a defense to most of these claims. Consent is not defined under these laws. And so, unlike a comprehensive privacy law that defines exactly what consent is and it's not, and how you can meet that definition, in the wiretap context, you're basing it on context and what the user experience is. And so, everybody, I think, has seen the rise of the banner, even though no US privacy law, state privacy law requires you to have a cookie banner on your site. It is a way of right away when somebody visits your site to have extra transparency. So there's that. Plenty of companies do that wrong. And so sometimes the language used on a banner can introduce more risk, or the choice mechanism that you tee up can introduce more risk if it's confusing or potentially misleading. That could qualify as consent if somebody is seeing language and responding to that. Are there counter arguments to it? Of course. And it's certainly the facts matter there. But that is only a defense for the claims where consent is relevant. There are these trap and trace pen register claims that were designed around the phone and communicating phone numbers as opposed to IP addresses. And so consent is not a defense to those claims. You've seen some ambivalence in some ways by the plaintiff's bar of those claims come up quite a lot in the demand letters. But to litigate those claims, and there are some being litigated, I think at its core, it's threatening that the internet is unlawful, just the design of the internet. And I think there's ambivalence on who really wants to see that claim go the distance. And right now we have them just pass a motion to dismiss, but not really any real substantive rulings on that. And that's one where I think we're, as a lawyer's lawyer, we're going to nerd out over like what that means. But I think from the don't be the low hanging fruit, and can you do enough things that make you not attractive for receiving any of those types of demands, or having it be at least a very low dollar type of demand? Yes, I think that's doable.
Do you have an ideal recipe or architecture for data collection, data storage, and data sharing for a privacy sensitive client?
Everybody is we were talking about home renovations and how it's always a work in progress. I think with data architecture and environments, nobody wants to do the home on display. I think everybody is working on that. I think partly it's because you're trying to retrofit in many ways as opposed to build from scratch. And retrofitting across different environments, there's a lot of work there to you don't know, you didn't have a business reason to know, in some ways at a granular level, and to be able to update instantaneously. I am seeing a lot more tools these days that help make that be a smarter exercise and a persistent. I think for so long we've relied on really manual. You think of privacy, and it was a GRC kind of function. And so everything was very manual, people filling out forms. Even if it was a digital form, you still have people having to analyze that. And so you can't scale that. And I think now it's a question of whether there will be enough enterprise demand for it. But there certainly are some smarter tools that when they say data map and data organizing, data provenance, there is a way to actually do that and persist that, like put in the legwork up front, and then be able to have kind of an always refreshed capacity there in terms of how it's categorized and tagging and alerting when you have certain sensitive data that's being used outside certain purposes, so that you don't have to really reinvent the wheel each time. That's rare. Like you don't see that a lot. But for all of the move I hear among businesses around, gosh, loss of signal, we want to, have a 360 of our customers, or, your prospects, and we're making all of these changes to make that happen. And yet doing that without really thinking about the governance structure behind it. Like, how could you have a consent strategy when you can't match a permission in real time, or a change in that permission status and the exemptions to that? And that means you can use it, but only for some restricted purposes. That needs to be a very constantly refreshed environment to do that. And yet, if that data is living and orphan data and being used by different teams in different manners where that's not all synced on the back end, you got a problem. And I think maybe what I see as the biggest problem among businesses is everybody's in a silo. You have this strategy over by this team and that strategy over by that team. And maybe they need to come up with a consent strategy, but nobody's talking across the business on what is the enterprise approach to this? What is the enterprise build over this, so that I don't even want to call them compliance solutions, because really they're enabling tools, but you need an overall approach to be able to invest and have the right architecture, and not death by a thousand cuts by doing it among different teams. But I think still in many ways that is what's happening.
I think there's an understandable anxiety and misperception that you can't drive performance if you go to full compliance. And that is not our experience. It takes a lot of work to get there, but we can actually drive better performance in a privacy first architecture. It's just
You've
not as easy. The
unlocked.
platforms make it super easy. It feels really easy to log in and have all this audience targeting data and tracking data, but it's an illusion. It's really inefficient. And so our spend is much more efficient. The outcome is the right outcome and is much more valuable, but we're not using third-party data and we're not sharing with third-party platforms.
You have a high confidence of what you can do with that data, so you don't have this delay in, can we get the right permissions? What can we do? What's the notice? What's the diligence? You've already done that up front. And so what I find is where companies who have done that, you've unlocked those restrictions that usually at least either create risk or create barriers from doing use case A, but not B or C. There's so much
Right.
nuance in that. And being smart about it up front, I think you do open up a whole lot. It's the word compliance. You hear compliance and it's just kind of this Debbie Downer, that like businesses do not want to hear that, as
Well, it's
opposed
immediately
to,
translated to no.
no, right,
Yeah.
legal, private, like there is a certainly a feeling that I think gets in the way of progress here. And maybe we just need to call it something else. But really it's about, I think it's data enablement and what are the tools that help you enable data. And that's both information, knowing what you can do so that you configure and you design and you invest in the right tools. But once you do that, like you're on the fast path to really do the kinds of just exciting business initiatives that really can get you far. And that's the competitive difference.
Yeah. That's certainly our experience. All right. So some of the most restrictive privacy regulations apply to healthcare and medtech. But there are privacy regulations more broadly for all aspects of ad tech and the internet as a whole. Our thesis is that the more restrictive environment that's applied to healthcare and medtech is coming for everybody eventually, and the eventually is in a fairly short period of time. What's your perspective on that? What do you think the privacy landscape will be in 3 years, 5 years, 10 years?
I think we're very quickly moving to a consent, at a minimum, a consent requirement for sensitive data. And so a strategy of let's take out these states, but we're fine in these other states that don't yet have these laws. That is not a long-term strategy. I think it's
Right.
very, there's just not a whole lot of mileage there. I had mentioned earlier on that the trend, right? We have different trends with new laws, and the trend now is focusing on very specific data. And the very specific data is health data. And I don't see that going away. I think you just zoom out and think about popular culture and our aging population and our needs. We're very interested as a population in our wellness and our want to live longer and our health stats and our data points. And all of that comes, there's a movement to direct to consumer so that you're not reliant on a carrier to be able to get you all those informations, that you have them on your phone and you can access and you're empowered to do so many things. And so with that, just societal movement to be empowered with your information and to be able to have the data to make your own decisions and work with companies who you want to work with to help address some of those issues, priorities. That means health data is just even more pervasive across different touch points, across different technologies, which means legislators are going to be more concerned and there's going to be more litigation because, go fast, break a whole lot of things on the way. Well, if you're going fast and breaking things with the most sensitive data, you're putting everything on the line in a way that's very foreseeable to blow up. And we're going to have examples of those. And the problem, unfortunately, is that makes it worse for everybody else, because then you tend to have new laws enacted that go even further, that get into bans or just outright prohibitions. And then those are going to get litigated and we're going to have to figure out where that nets out. So you can't be building your business in response to every new law. You really have to have visibility into, well, what is around the corner, so I have a more durable strategy and can build on top of that. And I think that trend line is really clear. These laws are just getting tighter and more restrictive and expect a lot more from you to be able to use that data with a very clear value proposition to the consumer so that they want to provide you with the kind of consent that you need to unlock those
Yeah.
data use cases.
And I think the more that you architect and begin to operationalize privacy first marketing practices, the more you're taking control of your own destiny and the less beholden you are to third party platforms and the whims of their policy changes or the things that they're going to do to conform your behavior and your investments to what's best for their business model, but not yours. So it's advantageous for all sorts of reasons. I think a couple of things are likely to happen. I think that we will have one or more catalyzing bad events, likely involving AI and disclosure of health data, and that the reaction to the catalyzing event will be very restrictive, as you
Right.
said. I also think that I hope that attention to privacy and true care will become an important brand signal rather than something that you have to do because it's a cost of doing business. So yeah, like you, I think privacy regulations are coming for everyone, and it's better to be proactive and maybe hew toward the more restrictive regulations now, so that you're ahead and you have that competitive advantage.
I agree with that. I think if I put on my cynical lens, there's a lot of froth right now. It's not really apparent that there is really business at risk type of legal exposure. And so when you look around, you're like, well, everyone's doing it right now. So that's a tomorrow problem for me, not a today problem. And today I'm going to get as much revenue as I can out of
Right.
the very loosey goosey practices. And we're coming up to that line. That line is really close, and then what? And then you just hop to another job, hop to another company that did invest. Like, I just this is coming, and I think the denial that might have worked a year ago, but I don't see it now based on the actual legal kind of brick wall that I am seeing in the way of enforcement and types of really tough legal exposure for some companies that don't have a long-term plan. I'm a lawyer and I'm usually talking to legal audiences. So I really appreciate this experience. But when I do these talks, it's usually privacy lawyers in the room, but not business folks. And I think the gap on real just understanding and information by CMOs and business, boards on really understanding where the landscape has shifted, like the conversation really needs to be taken to very different audiences so that it can be part of the business strategy. I'm always happy to be the stakeholder, but I think like the business stakeholder really needs to embrace and understand these to be able to build strategy on top of it.
Yeah, I absolutely agree. And our experience is that actually takes a lot of conversations and quite a long time. One of the things that we do for our clients is to design HIPAA compliant data solutions. So everything from moment of capture and first party data strategy and storage, and then control of data sharing down to a single data attribute. And we probably spend 75% of our project time on meetings with marketing and executives and compliance and IT, legal, just talking through how everything works repeatedly and understanding data flows and understanding why this is important and how the data is going to work or not work afterward. It's all change management and education. And then the actual technical work is really important, but it's the final 20 or 25%.
I couldn't agree more. I think those conversations have just changed. I think we're so used to using HIPAA words that that's all we had to talk about. And now that is absolutely not everything we need to talk about. So bringing in kind of the newer vocabulary and the newer subjects in those conversations. Yeah, more of those need to happen. Agreed.
Thank you for the conversation. I've really enjoyed it. It's a lot
Yeah,
of fun.
same here. Good questions.
Yeah.